Major breaking news involving the Second Amendment out of Kentucky. Another federal district court judge has concluded that another federal gun control law is unconstitutional under the Second Amendment and Nyserpa versus Bruin. Stay tuned. I'll break it down for you when we get right back. Hey folks, I'm Mark Smith, host of the 4 Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the 4 Box of Diner Second Amendment channel, please do so. We're trying to get to 100,000 subscribers as fast as possible to help us with the algorithm. Okay, breaking huge news. Another federal district court judge, this time in the United States District Court for the Eastern District of Kentucky, has found that the Second Amendment was violated by Congress and federal law by enacting 18 U.S.C. 922 G8. This says that if you are subject to a domestic violence order, which is a restraining order. We should talk about those separately, but we won't right here and right now. But the bottom line is, if you are subject to a so-called domestic violence order and you possess a firearm or try to buy a firearm, you are committing a felony. Well, in the case of United States versus Combs, Judge Danny Reeves in the Eastern District of Kentucky found that it is unconstitutional under the Second Amendment and Nyserpa versus Bruin to deny people their right to keep and bear arms if they're subject to a domestic violence protection orders. Okay? Now, his rationale and methodology, I think, was mostly spot on. There's one slight potential mistake he made I'm going to get to in just one second. But let's just start on the Second Amendment argument specifically, and then we'll talk about the second part of it. What he said, first and foremost, is he rejected the United States government, the Department of Justice argument. This is very important. I've talked to you about this before. As you know, under Nyserpa versus Bruin, with the exception of arms ban cases, which is not applicable here when we're dealing with someone who wants to possess a firearm and they're subject to a restraining order of some sort, okay? In cases where you are subject to a restraining order and you want to possess a firearm, the legal challenge says that the plain text of the Second Amendment, which is the right of the people to keep and bear arms, applies to you. Now, as you know, once the plain text of the Second Amendment, the right of the people to keep and bear arms, applies to you or your situation, the burden of proof, the burden shifts at that moment in time or goes over to the government, in this case, the Department of Justice. And their burden is to come forth historically with historical analog gun control laws around the time period of 1791 when the Second Amendment was enacted. Okay, so this is very important to understand this, especially if you're a law clerk, judge, or a lawyer, or anybody out there looking at Second Amendment cases specifically from the legal perspective. The anti-gun movement and the government is desperately trying to move any and all of their arguments against the Second Amendment into step one of this analysis. That's the plain text analysis. Because the reason why that's so important to the government is at the plain text analysis where they interpret the text of the Second Amendment, the burden of proof is more equally balanced, right? It's not officially on the government. So as a consequence, what the government is doing, and this is an example of what they're doing all across America, and mostly losing, but not entirely losing, they're arguing that the word the people doesn't cover all Americans. It only covers law-abiding, virtuous Americans as defined by the government. Now, this is not right. And Judge Reeves, in this case of U.S. versus Combs, disagreed with the Department of Justice, as well he should. Judge Reeves said, if you look at the Supreme Court precedent and the fact that the word the people applies, you find the word the people in no fewer than 4 separate places in the Bill of Rights, and in all, including the Fourth Amendment, by the way, and where you're talking about the people, it's talking about all Americans and not just so-called law-abiding Americans. And Judge Reeves made this powerful point that says, look, if you're only talking about law-abiding Americans, how does the word people apply in the context of the Fourth Amendment, which deals with searches, unreasonable searches and seizures? Because, of course, if you're a criminal, then you don't, according to the government's theory at least, if you're a criminal, you're not a law-abiding, virtuous person, which means the Fourth Amendment protecting you from unreasonable searches and seizures would not protect you. And Judge Reeves says, obviously, that's absurd and can't be the case. So in light of that, he says at the plain text step of the Second Amendment analysis, all Americans fall within the definition of the people. So all Americans whose rights are affected when it comes to keeping and bearing arms are protected at the first level, at the plain text. So Judge Reeves said that Mr. Combs' rights were infringed upon at the plain text level. So then he says to the Department of Justice, okay, you're the government. You now have the burden of proof, the burden to come forth with historical analog laws to justify at the time of our founding that someone subject to a restraining order lost their gun rights. So the government came forth with something they keep bringing forth and have since before Bruin, these so-called surety laws. Surety laws. And this is very important to understand this, because the government uses this all the time and it's totally inapplicable and does nothing good for them. If anything, it's actually a pro-gun position. I'll explain to you why in just one second. So here in the Combs case in front of Judge Reeves in Kentucky, the Department of Justice says, we've got proof, Judge, that there's a historical analog at the time of the founding that justifies denying people their right to keep and bear arms entirely based upon the fact they're subject to a restraining order of some sort at any level of society. By the way, I want to mention one thing about the restraining order that applied to Mr. Combs here in Kentucky. He apparently, according to the complaint, or according to the opinion, there was a restraining order as applied to Mr. Combs, but under Kentucky law, you are not entitled to have a court-appointed attorney represent you. So, of course, I don't know if Mr. Combs is rich or poor or what he is, but I can tell you this. A lot of people can't afford civil lawyers, and a lot of people just roll over on these restraining orders because they can't afford to fight it because they can't afford an attorney. So to me, that's why these restraining orders are very sketchy as to whether or not they're valid in terms of Second Amendment issues. But again, that's the subject of another video. So the bottom line here, though, is that Judge Reeves looked at these historical analog surety laws that the government proffered and said, this is the best you've got. This is clearly not good enough. Why is that? Because the way the surety laws worked was this. First of all, the first surety law does not come into existence in American life when it applies to taking away gun rights, allegedly, until 1836. I repeat, 1836. Now, you know from this channel that the latest the founding period can extend to is the year 1826, because on July 4th, 1826, Thomas Jefferson dies on the same exact day that John Adams dies. So on July 4th, 1826, and that moment in time, there's basically none of the founding generation is left. They're all dead. So obviously, to the extent you're trying to figure out what the Second Amendment meant to the founding generation that enacted the Second Amendment, after 1826, they're all dead. So anything said or done doesn't speak to what the founding generation understood the Second Amendment meant, so it's not relevant. So here you have this so-called surety law enacted in Massachusetts for the first time in the year 1836, which is at least 10 years after the founding period of American history. So it's too late and can't count because it's too late, as you know, number one. But beyond that, if you look at the substance of these surety laws, they actually do not help the anti-gun movement. Now, you're going to hear in op-eds, the anti-gun tweets on Twitter, and so on and so on, surety laws, surety laws, surety laws. And they're going to sound like, oh, smart and erudite, intellectual. Ooh, surety laws. Yeah, surety laws. Not at all. Y'all want to teach you how to be smarter like that and kick their butts because it's clearly not applicable. Here's why. The way the surety laws worked was this. Let's say in 1837, you're in Massachusetts and you think your neighbor is a danger to you, a violent danger to you. You go to court. Hear me out. You go to court and you say to the court, my neighbor is a danger to me. I'm scared and I want a surety to be posted by him. The court would then, under the procedural rules, say, okay, you come to court. I'm going to bring your neighbor to court. We're then going to have a trial. Hear what I just said? A trial to figure out whether or not your neighbor is dangerous. If your neighbor is deemed not dangerous to you, nothing. He doesn't lose anything. Doesn't have to do anything. You lose. He's not dangerous. If the neighbor is deemed, as a matter of fact, to be dangerous to you, then what is the remedy? And this is the key point, the neighbor does not, I repeat, the neighbor does not lose his right to keep and bear arms. The only thing that occurs if he's found to be dangerous is one of two things. He has to show that he has a need for self-defense specifically, or at most he has to post a small bond. Either way, he's allowed to continue to keep and bear arms. You see what I'm saying? He doesn't lose his right to keep and bear arms, even if the neighbor is found to be a danger to you. So think about that for a second. The anti-gunners today, including the Department of Justice, are trying to say these 1836 and afterwards surety laws enacted by places like Massachusetts, again, too late in time to speak to the founding generation, but even assume it's within the founding generations, which they're not, they're obviously too late, even assuming it's in a they're timely historical analogs, they still don't serve as analogs because they do not have the remedy if someone is found to be dangerous of taking away their right to keep and bear arms. It only requires them to post a small bond if they are deemed to be dangerous after a trial. That is a far cry, as Judge Reeves points out here in the Combs case in Kentucky, that is a far cry than what's going on in American life under federal law now, which is that if you're subject to a restraining order, you can't keep guns, or you can't use guns, you can't carry guns. All of your right to keep and bear arms is gone until that restraining order is over. That is dramatically different than these surety laws that the Department of Justice is hanging their hat on over and over and over again. And they keep losing, as they just did in front of Judge Reeves in Kentucky. So after Judge Reeves concluded that the government failed to come forth with historical analogs, Judge Reeves then dismissed the indictment for Mr. Combs allegedly possessing or buying a firearm while there was a restraining order. However, there's a second count that I just want to talk about briefly. Mr. Combs also sought to dismiss a criminal charge that he lied on his federal firearms form, right, when he buys the gun, the 4473 form. They said he lied because he didn't say he was subject to a restraining order. Mr. Combs argued that he did not have to disclose that he was subject to a restraining order because the underlying law was unconstitutional, and thus he had no duty to disclose that to the FFL because, again, the underlying law was unconstitutional. In this case, Judge Reeves actually upheld the charge and said that, no, I'm not going to dismiss that because it's an independent basis under federal law that you're not allowed to lie to FFLs. And therefore, even if it's not a material lie, I think you can still be indicted. That is what Judge Reeves concluded. Now, I've got a few reasons why that may not be true. I will shoot another video that addresses the question of whether or not Judge Reeves may have got that wrong. But again, for our purposes of the Second Amendment, which is what we're talking about right here, right now, a big win out of Kentucky. Judge Reeves concluded and threw out the indictment that Mr. Combs lost his right to keep and bear arms in its entirety because he was subject to a civil restraining order, which, as I mentioned, under Kentucky law, apparently, you can have a restraining order entered against you even if you don't have a lawyer because you can't afford one. I think that's inherently unfair, which is another reason why I don't like red flag laws, because you just punish people that can't afford lawyers, and lawyers are expensive. Even the cheap lawyers are expensive to most people, and it's unfair that you let these people lose fundamental constitutional rights without giving them adequate protections in many instances. But again, that's the subject of a separate video. Okay, again, breaking news, great news, another win for the Second Amendment, this time out of Kentucky. I'll keep you informed. There's a lot more coming down the pike, so stay tuned here at the Four Boxes Diner, and if you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.